Hi, I'm Natalia and I'm a real estate attorney here in the state of Florida, and I have some big news for you. Big news. So, yesterday, February 25th, 2021, federal court ruled what I have been telling my clients from the very beginning, that the CDC Moratorium on Evictions is unconstitutional. That means that the federal government does not have the authority to put in and impose a overwhelmingly generic stop on eviction proceedings because it does not have the authority that the states have. So this is the 21-page ruling that came out yesterday from the federal court in Texas, and I wanted to bring up some points that I thought were absolutely key to why this is not constitutional and why I've been telling my clients the exact same thing. So effective right now, the CDC does not have the authority nationwide to impose any stays on eviction through its CDC moratorium or affidavit or any of that. It's out the window now. Okay. So, key things from the ruling. The federal government did not do so in terms of putting in stays on evictions during the deadly Spanish flu pandemic, nor did it invoke such a power during the exigencies of the Great Depression. So one of the big things here is that historically, the federal government has never taken such an action, and therefore there is no historical basis for undertaking this type of stay or activity under the Commerce Clause of the Constitution. So, further information that is just absolutely essential in its analysis was that the federal government didn't have a sufficient tie to evictions. Evictions are by nature something local. Real property is by its nature local, and therefore the only entities that have the authority to put a halt, a suspension affecting property rights in this manner are the states. So in the state of Florida, it would be the state of Florida legislature, the governor of the state of Florida, who has the authority to impose these kinds of stays, but not the federal government. Let me read a clause that I thought was really important. So it says the substantial effects test. So it means, like, in order for the federal government to regulate something, it has to have a substantial effect on interstate commerce. That's commerce between the states or international commerce. And it says this test points that there has to be a nexus between the local activity being regulated and interstate commerce. And again, if you are just saying, hey, look, you can't get access to your property anymore because of this this COVID pandemic that we have taking place, then that has to have some sort of a tie to interstate commerce. And the reality is that it doesn't. It has no tie to interstate commerce, not in a sufficient, substantial way, which is what's required for the federal government to have authority over these types of events. So it says the challenged order regulates property rights in buildings. Specifically, whether an owner may regain possession of property from an inhabitant. Real estate is inherently local. Residential buildings do not move across state lines, and therefore there is no basis under the Constitution that allows this kind of authority for the federal government. The other concern that the court had here is that this order was attempting to criminalize the possession of one's property when inhabited by a covered person. Criminalize possessions of one's property. And not only that, but the possession of one's property is something that is a vested right under the statutes of the states. So in Florida, Chapter 83 of the Florida statutes is what gives authority of landlords to reclaim possession of their property. And the federal government's activity was essentially blocking that state-granted right to property owners, which was just constitutionally impermissible. So the fact that an activity has some sort of ultimate tie or correlation to national employment or socioeconomic statistics is not enough of a nexus to allow the CDC or any federal agency, in fact, to impose a stay on a state police power, which is the power of property rights between landlords and tenants, to take place. And because this is a non-commercial activity, evictions, meaning regaining possession of property, is not a commercial activity, is a property right activity. There was too much attenuation, too much distance between what Congress can do in terms of regulating transactions between the states and internationally, and what was actually taking place at the local level between landlords and tenants. So while the states are free to make stays and moratoriums on evictions due to the pandemic and health concerns under their general police power, the federal government does not have this authority, and therefore the CDC moratorium, the CDC affidavits, all of it out the window. This is my little update for you. It's huge. It's big. I'm Natalia Willette. I'm a real estate attorney here in the state of Florida, and I wanted to wish you good luck, investors, and let you know that you should not be bullied into not proceeding with regaining possession of your property when your tenants are breaching their lease agreements, including non-payment of rent. Thank you, and have a good weekend.